Hello, welcome to EPG Pathshala, course Legal Literacy. I am Maruk Edenwala. I'm a practicing lawyer and I will be taking this course. The subject, Child and the Law, Part 3. In this module, we'll be looking at two child-related legislations. The first one is the Immoral Traffic Prevention Act 1956, in short called ITPA, and the other is the Child and Adolescent Labour Prohibition and Regulation Act 1986, which was recently amended in 2016. Now, first, let us look at the ITPA, or the Immoral Traffic Prevention Act 1956. ITPA has been based on Article 23 of the Constitution, which prohibits traffic in human beings. Though the word traffic is used in the title of ITPA, it is not mentioned in the body of the Act, nor has it been defined. It was only in 2013 that trafficking of persons has been defined in Section 370 of the Indian Penal Code. The second bullet point denotes the purpose because of which the Government of India enacted the suppression of the traffic in persons and of the exploitation of the prostitution of others 1950. This was the law regarding trafficking, which was a predecessor to ITPA. Now let us see the definition of child under ITPA. Firstly, I would like to say ITPA has defined persons in three categories. First is a child, who is a person who has not completed the age of 16 years. The next category is a minor. That is a person who's completed 16 years of age but has not completed the age of 18 years. The last category is that of major. That is a person who has completed 18 years of age. These three categories are very important in ITPA as the punishment is more severe if the victim of trafficking is a child or a minor. This law deals with commercial sexual exploitation. It believes that both males and females are victims of commercial sexual exploitation. Statistics denote that the age of the child being put into commercial sexual exploitation is fast reducing and their numbers fast increasing. What ITPA does is it punishes exploitation of a person. It's exploitation that is punished. ITPA punishes the brothel keeper and the person who manages the brothel. Hence, it is as they are exploiting the persons in prostitution. They are the exploiters. So, we must first understand what is the term brothel. Section 2, subsection A defines brothel. Brothel includes any house, room, conveyance or place, or any portion of any house, room, conveyance or place which is used for purposes of sexual exploitation or abuse for the gain of another person or the mutual gain of two or more persons. So basically, brothel is any place from where a person is being prostituted. As exploitation is an important ingredient of this act, a place is treated as a brothel if you are able to show the exploitative relationship. Therefore, a person carrying out prostitution from a own home, such home will not be treated as a brothel. Prostitution. Section 2, subsection F defines prostitution. Prostitution means the sexual exploitation or abuse of persons for commercial purposes, and the expression prostitute shall be construed accordingly. This clarifies that this law deals with the commercial sexual exploitation of persons. Now let us look at certain different offences under this Act. Under Section 3, keeping or managing or acting or assisting in the keeping of a brothel is penalized. You will see that the punishment increases with the subsequent conviction. This is so because trafficking is recognized as an organized offense. And there is lots of monetary gain, hence a person will not give it up easily. A message has to be sent into society that if you continue with this trade, the punishment will become more severe. Section 4 penalizes any person over 18 years who knowingly lives wholly or partly on earnings of prostitution of another. This means that a husband who puts his wife into prostitution and lives on her earnings is an offender. So is a parent who puts their child into prostitution. This offense becomes more severe if the person in prostitution is a child or a minor. Section 5 penalizes the procuring, inducing, or taking person for sake of prostitution, whether with or without consent. It is important to note that consent of the victim is not a defense under ITPA. The offense will apply whether the victim has consented or not. But under Section 5, the offense becomes more severe if the person is procured, induced, or taken without such person's consent. It is important to note that in Section 5, the word trafficking has not been used, but maybe the terms procure, induce, or taking a person amounts to trafficking. Section 6. Detaining a person in premises where prostitution is carried on is also an offense, and it is treated very severely by the law. Prostitution is not per se an offense. It is the exploitation of the person in prostitution which is an offense. Hence you will see under Section 3, 4, 5 and 6, the person in prostitution has not been treated as an offender. The important ingredient is exploitation. Persons in prostitution are now referred to as victims of commercial sexual exploitation and trafficking. This law lays down a procedure for identifying such victims, removing them from the flesh trade, and rehabilitating them. Search and rescue operation. Who should the rescue team include? Point 1 mentions who the rescue team should include. It should include a special police officer or a trafficking police officer. Who is a special police officer? A special police officer is appointed by the state government. A police officer above a particular rank is generally designated as a special police officer. For example, in Mumbai, all police inspectors are designated as special police officers, and it is only they who can investigate cases under ITPA. Trafficking police officer. Trafficking police officer is appointed by the central government, and he has jurisdiction over the entire country, because trafficking as an offense is not restricted amongst the boundaries of a particular state. It is a movement from one state to another. Hence, trafficking police officers have jurisdiction throughout the country. The Central Bureau of Investigation has been designated as a trafficking police officer. The rescue team should include 2 or more panchas. That is, respectable inhabitants of that area, at least one of whom should be a woman. The woman need not be from that locality, because sometimes it is very difficult to find a female panch from that locality, because when you carry a search and rescue operation, the majority will be women in the brothel. Hence, the rescue team should include 2 women police officers. All persons found in the brothel are to be produced before the magistrate. Who will you find in a brothel? You may find the brothel keeper, you may find a customer, you may find a procurer, and you will find the victims of commercial sexual exploitation and trafficking. What is the procedure to be followed before the magistrate? The police have to file a remand application, which has to be very carefully prepared, because it should have 2 categories of persons. One are the offenders, means the brothel keeper, the trafficker, and second is the victims of commercial sexual exploitation and trafficking. It is also important to produce the customers before the magistrate. We have seen that section 4, 5 and 6 do not include the customer, but a customer is an abettor of this offense, and if the victim in prostitution is less than 18 years of age, he would also be guilty of penetrative sexual assault. The magistrate should direct medical examination of the victims. What is the purpose of medical examination? 1 is to determine the age of the person. 2 is to detect injuries due to sexual abuse. 3 is to detect presence of sexually transmitted diseases. On age determination, victims who are above 18 years of age are to be dealt with by the magistrate. The magistrate has to take care of their rehabilitation. But victims under 18 years of age are to be treated as child in need of care and protection, and their case is to be transferred to the Child Welfare Committee. All victims under 18 years of age, please note, are to be treated as children in need of care and protection and to be dealt with by the Child Welfare Committee. These slides relate to an adult victim of trafficking. We are more concerned with the portions of the law which relate to children. Change. We are more concerned with the portions of the law which relate to children. The scheme of the Immoral Traffic Prevention Act is to rehabilitate the person in prostitution and punish the person engaged in such exploitation. Under certain provisions, persons in prostitution are punished under under section 7 and 8 of the ITPA. Section 8 of the ITPA deals with soliciting. Section 7 deals with carrying out prostitution in the vicinity of public places. But it is important to note that a child or a minor involved in prostitution cannot be arrested for soliciting. This is an extremely important judgment. It indicates the link between the Immoral Traffic Prevention Act and the Juvenile Justice Care and Protection of Children's Act. This 2002 judgment of the Bombay High Court says that on rescue, a person under 18 years of age should be treated as a child in need of care and protection and should be brought before the Child Welfare Committee for their rehabilitation. It also goes on to say that if a child is produced as a child in conflict with law under section 7 or 8, such child too should be treated as children in need of care and protection. In fact, today, in most parts of the country, children who are arrested by the police for soliciting are not treated as children in need of, are treated as children in need of care and protection and not as children in conflict with law. Another important thing this judgment says is that no child rescued under ITPA should be released by the Child Welfare Committee without receiving a probation officer's report. The probation officer's report will denote whether the parent or guardian seeking custody of the child is actually the parent or guardian of the child, or whether it is an exploiter under the guise of parent or guardian. The second thing which the probation officer's report will indicate is whether the parents or guardian are fit to be given charge of the child. Because the most important aspect of this law is that the child should not again be pushed into such exploitative situation. Furthermore, it was noticed by the Bombay High Court that the lawyer who appears for the children are the same as those who appear for the pimp or the brothel keeper, and the High Court has castigated this practice. The Child and Adolescent Labour Prohibition and Regulation Act 1986. It has been recently amended in 2016. Earlier it was titled the Child Labour Prohibition and Regulation Act 1986. The earlier act was based on Article 24 of the Constitution, which prohibited children under 14 years of age to being employed in mines or factories or hazardous occupation. But now let us look at the provisions of the Child and Adolescent Labour Prohibition and Regulation Act 1986. This is the preamble of the Act. What is the preamble? The preamble is the objective of the Act. The preamble will inform as to what is the evil that this law is attempting to curtail, or what is the entitlement and rights which such law is attempting to grant. The preamble of the Child and Adolescent Labour Prohibition and Regulation Act states as follows: an act to prohibit the engagement of children in all occupations, and to prohibit the engagement of adolescents in hazardous occupation and processes, and the matters connected therewith or incidental thereto. So first it is important to understand who is a child under this act and who is an adolescent. An adolescent means a person who has completed his 14th year of age but has not completed his 18th year. So this law goes beyond the earlier Child Labour Act. It also deals with children above the age of 14 years. Child. Child means a person who has not completed his 14th year of age, or such age as may be specified in the Right of Children to Free and Compulsory Education Act 2009, whichever is more. Hence, this definition of child implies that the definition should be in conformity with that under the Right of Children to Free and Compulsory Education Act, in short called the RTE Act. It is important to note that the present definition of child under the RTE Act is a person who is not completed 14th year of age. Hence, this act recognizes the link between child labor and right to education. It acknowledges that a child in school will not be in child labor. Section 3. Prohibition of employment of children in any occupation and process. Section 3(1) is very clear. It prohibits a child, that is, a person under 14 years of age, from working in any occupation or processes, whether it is hazardous or non-hazardous. Its implication is that all children under 14 years of age should be in school and not at work. Therefore, today, no child in India under 14 years of age should be working. Section 3, subsection 2 gives an exception to subsection 1. Child rights activists are very upset and are campaigning for deletion of this subsection. Because subsection 2 says that a child may work where he helps his family or family enterprise, which is other than any hazardous occupation or processes set forth in the schedule after his school hours or during vacation. So at a particular level, it justifies a child under 14 years of age to work, with the caveat, doesn't use the word work, but uses the word help his family or family enterprise. We understand how important leisure and rest is for a child. Also how important it is for the child to continue with his education even after school hours. Hence, child rights activists are opposing this provision. Whereas others justify it by saying the family takes care of the interests of the child and will ensure that a child is not exploited. But a question begged to be asked is, haven't we heard of instances where the family too is an exploiter of a child? Another exception is where a child works as an artist in an audiovisual entertainment industry, including advertisement, films, television serials, or any such entertainment or sports activities except the circus, subject to such conditions and safety measures as may be prescribed. It is important for the audiovisual entertainment industry to lay down certain guidelines as to in what situation should a child under 14 years be working in such industry, because we have known of child working for very long hours in such industries. Of course, there is a proviso which claims that no such work under these exceptions shall affect the school education of the child, but this will be very difficult to monitor. Explanation to section 3, this defines family, what is meant by the term family under this act, what is meant by the term family enterprise under this act. Also, it defines the term artist. Artist means a child who performs or practices any work as a hobby or profession, directly involving him as an actor, singer, sports person, or in such other activity as may be prescribed relating to the entertainment or sports activities falling under clause B of subsection 2. Section 3A lays down this provision. No adolescent should be employed or permitted to work in any of the hazardous occupation or processes set forth in the schedule. These are the 3 occupations and processes mentioned in the schedule. Under the old act, there were several more. Hence, child rights activists feel that this schedule is most inadequate. Offenses. Certain offenses have been created under this act. Under section 14, whoever employs any child or permits any child to work in contravention of the provisions of section 3 shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 2 years, or with fine which shall not be less than 20,000, but which may extend to 50,000 rupees, or with both. So, employing a child in contravention of section 3 has been created and treated as an offense. Under section 14, subsection 1A penalizes those who employ adolescents in contravention of section 3A. Now let us look at certain provisions which examine the regulation of condition of work of adolescents. An adolescent may be allowed to work in non-hazardous occupation, but their work should be for 6 hours in a day. During that 6 hours, an adolescent should have rest of 1 hour. An adolescent cannot do night duty, means he cannot work from 7 p.m. to 8 a.m. nor can he do overtime. Also, it is important to note that an adolescent should get 1 day holiday in a week. Certain monitoring mechanisms have been set out under this Act. 1. Inspectors. 2. District magistrates. 3. Appropriate government to cause periodical inspections. Child and adolescent labor prohibition inspectors have to be appointed by the state government. They have to ensure compliance of this Act, as does the district magistrate. It is also important to note that the government should ensure that inspections are periodically carried out either by inspectors or by any other persons. Rehabilitation Fund. This provision is due to a Supreme Court judgment, M.C. Mehta versus State of Tamil Nadu, where the Supreme Court acknowledged that one of the main reasons for child labor was poverty, and innovated a scheme by which, though the child is removed from labor, the family would get some amount by which the child could be sent to school. Section 14B reflects that portion of the M.C. Mehta judgment. It states the appropriate government, which could be the state government or the central government, should constitute a fund in every district or maybe in one or more districts. That fund should be called the Child and Adolescent Labor Rehabilitation Fund. Any fine which is collected from an employer who has placed a child or an adolescent into employment in contravention of the Act, such fine should be deposited in such fund. Furthermore, that child should also, or adolescent, should be rehabilitated in accordance with the juvenile justice legislation. Over and above the fine, the appropriate government should credit an amount of Rs 15,000 to the fund for each child or adolescent for whom the fine amount has been credited. Technical Advisory Committee. The Technical Advisory Committee is to be constituted by the central government. What is its task? Its task is to declare certain processes and occupations as hazardous, or to omit certain occupations and processes from the category of hazardous. In the end, I would like to say that both Immoral Traffic Prevention Act and the Child and Adolescent Labor Prohibition Act, its implementations depends upon the age of the child. So it is very important to follow a procedure to identify what the age of the child is, because very often the exploiter attempts to portray that the child or adolescent rescued from a brothel is an adult and does not require to be covered under the Juvenile Justice Care and Protection of Children Act 2015 and does not need to be rehabilitated by the Child Welfare Committee. So all attempts will be made to show that the child is older than what he actually is. Hence, social workers have to be very clear to see that the procedure laid down under the Juvenile Justice Act is followed to ascertain the age of the child.